Good evening. We are here for the Board of Commissioners meeting, Franklin County. The day is Wednesday, August 28th, 2024. 7 o'clock. I'll call the meeting to order, and please ask that you join me for the Pledge of Allegiance. Adoption of current agenda. Any additions or corrections?
Yes, Mr. Chairman. Under regular business, item number 1, instead of a resolution, that needs to be approval of contract. That's all from me.
Okay.
So with that, I would move for approval of the amended agenda.
Second.
We have a motion and a second. All in favor signify by saying aye.
Aye.
Aye. The motion passes. Approval of minutes.
No corrections or revisions.
No corrections.
Approval of warrant registers and payroll rosters.
We've got two this evening. The first is Umpqua and excise tax under fund expenditures. Mr. Chairman, I move to approve fund expenditures in the amount of $6,194.21, and note that it has been reviewed by two members of the Auditor's Office and our Administrator, Mr. Johnson.
Second?
I have a motion and a second. Any discussion? All in favor say aye.
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 Aye. Motion passes.
Mr. Chairman, I move for fund expenditures in the amount of $945,596.71. And again, it's been reviewed by two members of the Auditor's Office and reviewed and signed by our Administrator.
Second?
We have a motion and a second. All in favor say aye.
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 Aye. Motion passes. Moving on to public comment. Is there anyone in the room for public comment? If so, come forward, state your name, and you have 3 minutes.
Good evening, Commissioners. My name's Lon Clark. I've been here before a time or two, but I'm looking for an appointment for the South Columbia Basin Irrigation District, Position 3. And every once in a while, I get a piece of wisdom, and I get some from Teresa and from some Rocky, and I get it from everybody, even you, Clint. But it's constructive, and it has been very helpful. And I guess if you give it time enough, it might even call it wisdom. But persistence is one of the words I heard today. Persistence as long as it's constructive. And that's what I'm trying to be, is constructive. And so some people, I've taken a little bit of a beating over trying to get this appointment, not from you or anybody else here, but maybe from people out in the area. But I'm just trying to put some ideas out, some creative ideas, some good ideas forward for the South Columbia Basin Irrigation District, because it is lacking a position right now, and it needs to be filled. It's very important, and especially when we're coming up on an election. And there's some issues with the election procedures, too, which we're going to have to clarify maybe at the next meeting. And but it's kind of interesting, because my wife said something the other day, and it really made my buttons pop. She's a clerk up at Walook, and a farmer came in, and he was out of water. He was going into excess. And she said he came in that door, and he was upset, and real upset. And he was really mad at his ditch rider. She said, well, sir, if anything we can do to help. And he said, well, no good so-and-so. She went on. And she said, well, you need to go talk to him first and see if you can solve the problem. And he says, well, I can't talk to him. He's just too hard to talk to. And she said, well, talk to him, and then if you can't resolve it, you come back and see me. And he said, well, what good is that going to do? They're just going to hit me with overage charges. And she said, well, if that doesn't work, you can go downtown. She goes, well, what good does that do? They're not going to listen. And she goes, well, sir, I says, I work for you. I am an employee of yours. I am your employee. I'm here to help you. And, that just changed everything. And that guy quieted right down. And she said, well, could you please talk to your ditch rider first? And he said, okay, I can do that. I'll go do that. And I guess they got it resolved. Some missing cards. A lot of people aren't ready to go to the technology and use the portal to order their water. And it's caused some issues for quite a few people, and that's coming up at a next board meeting. I'm not part of that board meeting at this time, but I will be there to help mediate, I guess, for the other person. But in the meantime, I was real proud of her. It just made me so proud. You know, I almost want to cry because she just said it was just so profound. And that's where I want to be. I want to be there to help be constructive. And that's kind of all I'm trying to move towards right now. And I hope you guys will take that into consideration and work to fill this position, because it is important. It's imperative. It's not something that can sit and wait another week or two or a month, because we do have 4 more board meetings before this new, whoever it be, whether me or anybody else, gets onto the board. So we have 4 more months of meetings that we have to be consider. And during that period of time, we also have election. And those issues need to be resolved too. So anyway, I've taken enough of your time. It's a long evening. I thank you very much, commissioners, and look forward to seeing you soon.
Thank you.
Good evening, Commissioners. John Roach. And I'm here just to share a quick note of encouragement about I know the ongoing dialogue and negotiation with the Benton County Commissioners on the question of the interlocal agreement that is hopefully at hand as relates to the recovery center and the usage of the sales tax revenue from Franklin County to help get the initial build over the line. I am a member of the Behavioral Health Advisory Committee. I was appointed by Commissioner Didier a couple years ago, and that's been a great experience, and that's been a lot of great work that commission or that committee has done. But I'm more here as, you know, someone who's been in recovery and part of the recovery community in Franklin County and in the Tri-Cities for the last 16 years. And, you know, who 6 years ago or so when the sales tax bill was passed by all 6 commissioners, just felt like it was such a milestone moment for finally getting the services that, you know, we in the recovery community and the law enforcement community and in the healthcare community all know have been desperately needed here for a long time. And so, you know, we've been now on that road for 6 years, and we're at an inflection point. And I know that, you know, from a Franklin County perspective, we need to be good stewards, and we need to make sure that the language is right and that it's put together in a way that, yes, protects our interests from a you know, fiduciary responsibility perspective. But I just hope that as, you know, hopefully the final pieces of getting that thing over the line come together, we can also remember that, you know, this has been a long time coming. It's desperately needed. And anything that, you know, we can do to make sure that we don't get hung up on any last minute, you know, bureaucratic hangups or fights or anything like that would be most welcome by thousands and thousands of people in this community who are anxiously awaiting those signatures. So thank you.
Thank you. Anyone else in the room for public comment?
Hello, Commissioners. My name is Sam Cosillo. I'm here representing Local Meat Processing. And I wanted to talk to you guys about what our plans are for our meat harvest processing plan that we're trying to get approved. Can I do that, or I see you?
Apparently, no. I'm sorry.
Okay.
Not at this point,
Okay. Oh, sorry. We thought it was.
but thank you. Anyone else in the room for public comment?
Good evening, Michelle Andrews. I don't know if you noticed in the Olympian, Mr. Kilmer is suggesting to give land back to the Quinault tribe. And we specifically have a resolution about that. Whereas 90% of 1,754 square miles that make up the Clallam County are already set aside as state-controlled trust lands or private timber resource lands, along with major portions of the 922,650 acre Olympic National Park and 3,677 acre Olympic National Forest. And whereas less than 175 square miles of Clallam County remains available for all other uses, including agriculture, cities, homes, businesses, manufacturing, industry, and public infrastructure. Whereas owners of private properties that are targeted for conversion to public property coercive forces designed to compel them to become willing sellers, and whereas working multi-use timberland produces valuable economic, cultural, and environmental benefits surpassing those of restricted and neglected parkland and wilderness, therefore be it resolved that we oppose the Wild Olympics campaign and the Wild Olympics Wilderness and Wild Scenic Rivers Act covering 126,000 acres, introduced by Democrat Representative Derek Kilmer and Democrat Senator Patty Murray, in favor and strict policy of no net loss working forest land, working resource land, and private property. They're basing it on a treaty. We do not have treaties with other American citizens. Tribal members are American citizens. Those are resolved through the Dawes Act and then through the Reorganization Act. And he's quoting the Allotment Act, but we also have the Enabling Act. And we have to be very careful. I'm not against tribal people whatsoever. My mom grew up in Omak. But I am against tribal government trying to take more and more land based on a treaty, because when you open that door, the equal footing doctrine will go across the country, and it's not correct. Thank you.
Thank you. Anyone else in the room for public comment?
Good evening.
Good evening.
My name is Erin Petty. My husband and I, Jay, are farmers here in Pasco County. In fact, Jay's a third-generation farmer. Both of us have dealt with family members who live with mental health struggles and addiction. One is living with a TBI right now due to an accidental exposure to fentanyl, and another has passed away due to her addiction. We are part of a fraternity that we never wanted to join, and we have dealt with that for decades. I'm also a proud member of the Behavioral Health Advisory Committee, which is dedicated to the Columbia Valley Center for Recovery.
Would you talk into the mic a little bit more direct, please? Thank you.
Yes, thank you. I've attended several meetings here, and I know that we have your support. Everybody here agrees we need this center. But I'm here to express that we got to do it right. There's that great saying, build it and they will come. But we have to build it right. These centers have been built, people came and people left because they didn't get the help that they needed. I've done research on things that are really needed, and one of those was from the Department of Veteran Affairs. They put out a design guide that says that we need to have courtyards when we build these centers to give healing through natural light and views of nature. The publication by the New Scientist reads that studies have shown these green spaces have positive effects on depression, anxiety, and mood disorders, and they can be used by all. These aren't just good ideas, they're necessary to a good design. Private rooms can shorten the length of time residents stay in hospitals. Being away from home can be overwhelming. Private spaces increase healthy sleep, decrease levels of anxiety, and even allow for privacy during meetings with therapists. An industrial kitchen is another ask, and it's not a luxury item. Meal times are therapeutic. According to the Journal of the Academy of Nutrition and Dietetics, nutritional education is so extremely important to addiction recovery. Healthy diet fosters physical and mental health of those individuals while also increasing long-term sobriety. We have an opportunity to join our partners in Benton County to add these extra monies to make sure that as our neighbors watch, as our community watch, the entire state, pretty soon the whole country is going to be watching what we build. And I just implore everybody that you allow us to build it right. Thank you.
All right, thank you. Anyone else in the room for public comment? Moving on to approval of a consent agenda.
Mr. Chairman, I move for approval of consent agenda items 1 through 6.
Second.
There's been a motion and a second. All in favor, say aye.
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 Aye. The motion's passed. Consent agenda. Moving on to regular business. Resolution 2024-0191, HAPO Solar Grant presented by Jeff Briggs.
Good evening, Commissioners. And this was on, I believe, 2 weeks ago, where we had discussed this matter with McKinstry as well. Actually, Commerce wasn't there, but I'd met with Commerce about the proposed solar grant. So they're going to reimburse us for 70%. I did look into the concerns of the commission, which was the other 30% coming from the investment tax credit, which does appear to be a viable source for that other 30%. I also discussed this with our finance director, Mr. Anderson, who informed me that we could likely use .09 funds for that. We have a substantial amount of .09 funds. And potentially we could even use the HAPO fund for it, but we're not sure how much outlay is going to be, furniture outlay is going to be out there before it's reimbursed, because we hit milestones and then we're reimbursed periodically throughout the course of the project. But it does look like this would be a good fit for the HAPO Center. It does fit into our overall EBSCO contracting with McKinstry, putting us on that path towards meeting those clean building energy standards or clean energy performance standards. So overall, it does look like this would be a good option for the city, or sorry, the county rather, to move forward on this. So I would recommend a motion authorizing either myself or preferably, I guess, the county executive to sign the agreement with the Department of Enterprise Services, with the caveat that he be allowed to correct any sort of Scrivener's errors. I did notice in the version we have attached here, for example, there's a couple of comments. I think those are from Commerce to Department of Enterprise Services. I'm not sure there's not an author, but I noticed this is an edited version, so it must have been attached, and I'll take the credit for that. I must have sent the wrong version to Teresa, so.
There's a couple dates that were.
Right. The dates in a chart at the very bottom are reflected as quarter, and the comment is, please update those. Instead of saying quarter two, put the actual month and year.
So as it was stated earlier, or Mr. Chairman, as it was stated earlier, this is not a resolution. This is just an approval of the contract.
Right. Well, contract could be approved by a resolution. So if you prefer, I could come back in a week with a resolution, with some whereas clauses and stating the county's authority to sign a contract. You can also do it by motion. If you prefer to do it today, you can make a motion and authorize the county administrator executive to sign that.
Okay.
Mr. Chairman, I'd make a motion to approve the contract as presented to us and authorize the interim administrator to sign that contract with any needed Scrivener or date errors adjusted.
Second.
We have a motion and a second. Any discussion?
Yes, Mr. Chairman. So this doesn't get us to the level we want to be on these, the building. How close will we be? Do you know?
We still have, I think this was tacked on to phase 2, so we'd still have phase 3 to meet. So there's additional upgrades that need to occur with the HAPO Center to meet those standards. And so I would strongly suggest, we have a lot of .09 funds, utilizing those. I believe we have 8 million .09 funds. I'd strongly recommend utilizing those to fund these improvements to meet that.
As needed, if those other, if the tax credit thing is slow in what word am I looking for? If it's slow in the refunding process, that we would use the .09 funds to cover that.
Right. For this phase, and that's just for the solar. The investment tax credit is just for the solar, as well as this Commerce grant. For the remainder of the improvements, we would need to fund that, I believe, exclusively through .09 funds or some other source of funding, but.
And
that
we
does-
have received a $3 million grant from the state, or it's a budget item of $3 million to help cover that. That would be then finished by the .09 funds.
Are you referencing the solar?
No, the next phase.
Oh, the next phase? Okay.
So we have a motion and a second. No further discussion. All in favor signify by saying aye.
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 Aye, the motion passes. Moving on to Resolution 2024-0207, starting salary exception for OPD office assistant, presented by Jennifer Moore. Good afternoon.
Good afternoon. We have our current office assistant leaving as of August 30th. So we are looking to hire a candidate that we found who is already working in an Office of Public Defense area. So they have already the experience that we want. And in fact, one of the big things that we do is assign for Superior Court attorneys to clients, and he's already been doing that. He has that. He's had like almost a year of that experience. So we're wanting to hire him at a grade 14, step 6, since he already has the experience, the skills, and the knowledge that he would be bringing with him to the OPD office. And so the physical impact will be over $3,000 for the remainder of 2024, but we feel that this is a great step in the right direction. He would help me immensely in my as the office coordinator. And I can tell you from my experience, I actually worked with him over in Benton County, so I know he has a lot of experience to bring to us and a lot of skills. So we're hoping to do that.
What is the normal grade step that he would be hired at?
The one that's in right now is at grade 14, step 1. It was 47,000, just over. But I know when he was brought in, he didn't have as much of experience as our candidate now.
So, excuse me, Mr. Chair.
Yes.
So our employee that is leaving currently at a grade 14, step 1.
Correct.
With 2 years experience.
He did not have the experience in OPD specifically.
The employee that we have today has been here approximately 2 years.
No. Oh, no. Miguel only started in, I think it was February.
Okay.
Yeah. Miguel is, yeah. He only started here in the Office of Public Defense February or March. I can't remember the exact month, but I know it was earlier this year. So the one that we're bringing in, he's been the Office of Public Defense in Benton County. So he already has the experience. He's been over there for over a year, almost 2 years there. So he's had more experience.
So if you had 2 years of experience in Franklin County, what grade would he be at, or step?
I don't. 2 years experience. I was not told this. This is my first time doing it. I'm really sorry. So
I believe they would be at a 3. They would enter at a 1. It's 6 months. I think they can advance to a 2 if they pass a probationary period. So likely in their second year, they would be in a 3.
And we were trying to match. I mean, to be honest, we were trying to also match what he's making at Benton County, so he doesn't have to take a huge pay cut since he's already at that level.
So, Mr. Chairman, we're under a tight budget right now. We're trying to make sure that we keep this thing pretty tight as far as our budget. I would, since he's already got experience, I'd like to see him start at a 14.2 and 6 months later, maybe move him up to a 14.3. Does that sound reasonable?
Was, I guess would be reasonable. I would say what the experience that he has, had he been here, would still put him at what, a 3?
14.3.
At 1 year, it would be 2. So you would start at a 1, 6 months later, you would move to a 2, and then you would, after a year then, you would be eligible for a 3.
And you say he has 2 years of experience in Benton County?
Mm-hmm.
So the ASR here says with 1 year experience, over 1 year experience. Looking down the road at the fiscal impact, so this fiscal impact of 3648 through the remainder of this year, trying to do the math on what that impact would look like on next year's, that would increase that position's salary by 13,000 roughly per year. Is that fairly accurate?
That's fairly accurate, yes.
So I would be in favor of the recommendation that Commissioner Didier made of beginning it at a step 2 with the probationary period ending and being eligible for a step 3.
That was a second.
I'll second that.
All right, so we
If
have,
that was a motion that you made.
so we have a motion and a second. Any further discussion? Hearing none. All in favor signify by saying aye.
Aye.
Aye. Thank you.
Mr. Chairman, before you go into the closed record hearing, if I could just give a quick update. I know it's a little out of sequence, but I think there's a number of folks that are here for the Recovery Center that might not want to stay through the closed record hearings. And I just want to give a quick update on the discussions I've had with Benton County so that they are well aware that we are in communication with Benton County. I've met with Mr. Rasmussen once in person. We talked on the phone, I think, yesterday or today. We've presented them with an alternative interlocal agreement that is, I think, more streamlined and more succinct to what is beneficial to both jurisdictions, but to also looking at the allocation of that $4.47 million for the betterment. So we are certainly progressing at the direction of the board towards an agreement that would be agreeable to both counties. So I just wanted to give that update. At the direction of the board. It still has to come back to both boards, but I just wanted to make sure that before those folks had a chance to leave, that they did realize that the direction the board has given to staff, we are progressing on those discussions. And so they're more than welcome, I think, to stay for 3 very exciting closed record hearings, but they may not want to do that.
Yes, well, thank you for the update because I've had quite a few calls on that to find out exactly where we're at, and I think we're all in favor of it. I don't want to speak for all 3 of us, but we just got to make sure that we do it legal, and it is taxpayer funds, so we just have to make sure that it's done correctly.
And Mr. Chairman, and that we're committed to that 4.74. We are committing ourselves to that 4.74.
Yes.
I would love to get an update on it. I did visit the Columbia Valley Center for Recovery today and seen no evidence of any construction activity. And the last update that I believe we received indicated that there was anticipated to be construction starting in July or August. And didn't see that. Would love to know, kind of where we're at and what steps are, when that's gonna take place.
All right, thank you. So at this point, I will open the closed record hearing, Resolution 2024-0199, closed record hearing, CUP 2024-05, Galassi Mine, presented by Derek Bratton, Planning Director.
Thank you, Chair. Yes, this is a request for a conditional use permit to set or site a open gravel mine. There's currently no site address assigned to the property. It's on parcel number 113160017.
Pull that mic a little closer, please.
The total, okay, the comp plan is agricultural and the property size is approximately 800 acres. Its location is south of East Foster Wells Road, east of North Capitol Avenue, and north of Pasco Colotis Road. As mentioned, this is to allow for the development of a surface mining operation to extract available sand, gravel, and rock for commercial use. The property owner is the city of Pasco. The mineral rights owner is Gary and Carol Maugan. Area to be used is approximately 200 acres over the course of a 50-year period. That was according to the application. Application is for the development of an open pit mining operation, and that would be, those require a conditional use permit in the AP20 zone. So here's the subject area. It's the in the red boundary there. On or about April 11, 2024, staff sent notices to technical agencies, property owners within 1 mile in the Franklin County Graphic. We also posted a pending land use action sign on the property on April 23, 2024, and issued a SEPA optional determination of non-significance. And that was submitted as SEPA registry 202-401-487. We received comments from Public Works regarding concerned approach permit requirements, site access requirements, and compliance with road restrictions. Department of Ecology submitted their standard agency comments. The City of Pasco submitted comments on May 1st as the surface rights owner in opposition due to the lack of permission and negative impact to their use of the property. Public comment, we did receive one public comment that was in support of the proposal. And when I say public comments, I mean people we sent those public notices to. That's what those refer to. The City of Pasco and everybody else there is also public, but that's not what we mean. And we received no public comments against the proposal. During research of the application, it was discovered that approximately 561 out of the approximately 800 acres of the property has an agricultural lands of long-term commercial significance designation, an ALTAC. There is approximately 158 acres that do not have an ALTAC designation. On May 1st, 2024, the city responded that they were opposed to the proposal on 2 grounds. Applicant did not receive their permission before the application was submitted. Potential negative impacts to the process water reuse facility, because this is where it's part of their land where they dispose of that's been approved to receive that effluent after it's been processed. Public Works was concerned that there's issues with the main access road not being an all-weather road, and that there would be potential limitations on commercial vehicles based on frost-thaw cycles. So if this is to be a year-round operation, the applicant would need to coordinate with Public Works regarding the specifics of those limitations, and they would be required to abide by any. So it's a long-winded way of saying potentially the site could get shut down due to road conditions as it currently sits. Staff then sent an inquiry after we received the City of Pasco's comments. We went, well, we better double check with DNR, because our understanding is basically aligned with DNR's, which is that both landowner and mineral rights owner must sign off on their application. So we pulled the item before it could be held at the Planning Commission in May. And in order for both the parties to see if they could come to an agreement, the applicant requested that we can continue to process the application. So we moved it forward without an agreement in place regarding the surface rights issues. As of this date, no agreement has been reached. Staff is suggesting that if this item is approved, we will return to the board with an amended resolution indicating such, and recommends including the following conditions if that is the direction the board asks us to go in. No mining operation shall occur until such time as the applicant has come to an agreement with the surface rights owner. No mining operation shall occur until such time as the access to the property is improved to the standard required for the accommodation of commercial vehicles as determined by Franklin County Public Works. And any proposed mining operations will be limited to lands without the all tax designation until such time as the other sections of the property have gone through the de-designation process. So basically what would have to happen is they need to be de-designated during the comprehensive plan from all tax, and then they would need to be converted to mineral rights, or a mineral, basically the mineral version of an all tax, mineral land of long-term commercial significance. So PC adopted the following recommended findings of fact, and the proposed use in the AP 20 zone is not in accordance with the goals, policies, and development regulations because they don't have those agreements in place. It will adversely affect public infrastructure such that it will impact the city of Pasco's reclamation, and that has pretty significant ripple effects through all sorts of aspects of what goes on in our agricultural. Proposal will not be constructed, maintained, and operated to be in harmony with the existing or intended character of the general vicinity. And the location, the height of the structure, and site design will discourage the development of permitted uses. They won't, right now it's permitted for ag uses. That would potentially go away. Staff didn't determine that it would be any more objectionable to agricultural activities, both produce noise, dust, lights, not too many lights. And it would not endanger the public health, safety, or general welfare if it's approved as a mine, it's approved as a mine. They would have to have mitigating circumstances, things like wetting the surface and everything like that. So with proper mitigations, it shouldn't endanger the public health, safety. If the motion is for approval, along with the standard CUP approval language, the applicant shall comply with the requirements, or it's recommended that the applicant apply with the requirements from the following agencies: Washington Department of Ecology, Franklin County Public Works, Washington State Department of Natural Resources. Same conditions as mentioned earlier. No mining operations would occur. No mining until such time as they've come to an agreement. Till the road's been properly accounted for and an arrangement with Public Works is worked out, and that they would be limited to the all tax. Sorry. Are there any questions?
So currently it's an agricultural use and they're farming it, correct?
Correct. And it's a designated spot for the water that comes out of the processing plant, the reclamation plant, can't just be spread around the county willy-nilly. They have to go through an approval process. Specific acreage is designated based on the volume, production, and other variables. That's been done, and that's what that land is being used for, is for crops. I don't know what kind of crops. Basically, though, the primary purpose is to get that effluent to where they can clear their systems out. I mean, get that water out of there. Because you can't drink it,
So there's leases to farm that land correctly? Am I correct?
I would presume.
I guess
I don't know who is farming. It's not really, for our analysis, wasn't relevant as to what or who. It's really a matter of
how would you farm it if they're mining it? I guess
I'm sorry.
My question is, how would you farm it if they're digging a mine?
Well, that would create an issue, and that would, like I said, there is some land out there that is all tax. or I mean, not designated as Altac. That's a pretty small portion of the property. But yes, it would take it out of agricultural production.
All right.
Yeah, Mr. Chairman.
Yes. Chair recognizes
So-
Commissioner Didier.
I think the bigger issue is they didn't talk to the property owner before we started this process. And that's the city of Pasco. And I take it that they bought that from their mineral rights owner. They bought their land from the mineral rights owner?
I wouldn't be able to speak to that as to the exact purchase arrangement that occurred between the city and how they did that. And
Well, in all
again,
my dealings with ground, when you buy ground, you buy those mineral rights too. So
No.
you
not always.
Not always?
Not always.
Well, I have
that
in
is
all
an
my
old,
dealings.
That is an old saying that you ain't bought the land until you bought the mineral rights because of that. But generally, and under DNR regulations, both parties have to agree. And then,
Well, the
as-
keep factor here is the landowner hasn't given them, they haven't came to an agreement. There's no agreement here.
Correct. The applicant's interpretation is that their mineral rights supersede the land use rights. But that is not staff's interpretation, nor is it, from what we understand, Department of Natural Resources interpretation.
Mr. Chairman.
Yes, the chair recognizes Commissioner Bauman.
So, as far as I can tell, we have an incomplete application. Is that accurate? Because we don't have the landowner has not signed on to this. So that's one question. The second question is, did the applicant produce the mineral rights saying they had a right to this?
They do have paperwork that indicates that, but again, I'm not a lawyer. I mean, they have a mineral right. And who has rights and whose rights supersede, that's way beyond my pay grade. All I can look at is we have these requirements. Some of these requirements, in our opinion, has not been met, and hence our recommendation.
I see the attorney looking at me.
Well, we do have, and are you done then with the staff report, Mr. Broughton?
Yeah, I'm done with my staff report. I do have a
Okay.
suggested motion if asked. And yeah, I would open it up for
I would say
questions.
we're in a closed record hearing / appeal. I mean, this wasn't appealed, so technically the planning commission's recommendation or findings were never disputed. So it's kind of an odd procedural posture we're in right now, because I imagine the applicant doesn't agree with the planning commission's findings, but on the other hand, they didn't appeal it. In either case, our code's a little bit sort of wonky in this area. It talks about procedures for both, but then it seems to only talk about parties being able to present on an appeal. I'm sort of reading those more liberally. If there's a CUP that's before the board, and the board certainly has the authority to approve or deny or modify that, it seems probably germane to those proceedings to have the parties in interest, so both the city and the applicant, an opportunity to plead their case to the board. In doing so, though, I would caution them not to allude to facts outside of the record. It does appear, based on what I've reviewed, that it's disputed whether they own the mineral rights or not. And so at this point, the record's closed. We can't accept new evidence on that point. So if the board wanted to entertain that, I can see that they're both here tonight. That's up to the board, really.
And you will be the monitor to make sure they stay within the lines?
Oh, Mr. Harper probably has a better memorization of the record than I do, but yes, I'll do my best to do that. So,
All right, we'll move forward with that then.
okay, I guess we'd start with the applicant. Is that over there in the?
My name is Lynn Hall, and years ago I worked for Glacier Park Company, which is the one that owned the land and the mineral rights. And at the time that the city bought this land from Glacier Park Company, They met with us, they met with our attorneys, they sat down, they came up with an agreement. And one of the agreements on that particular deed was that there was an exception, that the mineral rights were reserved and not granted to the city, but that in that exception, it also said that you had the permission as the owner of the mineral rights to enter on the land anytime you wanted, to explore for mineral rights, to extract mineral rights, and to remove those minerals from the land. And so that maybe clears things up a little bit as far as what the minerals said. And we've sold other land, for instance, out at the processing area from the Port of Pasco on 395. They came to the owner of the mineral rights and bought those mineral rights from the owner of those mineral rights after they bought the surface, so that they would have a complete package. And that was not really expounded on at the time that I was out of town when I heard that hearing. I listened in on part of it over your system, and it was good. But I just wanted to point that out. And really, if you don't allow, the city is pretty adamant that if you step foot on that land, we're going to arrest you. And that's not the case. You can't do that when you've already agreed to the fact that you have the right to the mineral rights. You can come on anytime you want. You can mine those mineral rights, and you can remove those mineral rights. So this is not, and you got to remember that we're talking about a long period of time. This is not something that's going to occur overnight. There won't be a big hole in the ground out there for the next 50 years or whatever, how long it takes. You and I and the rest of us will be gone by then. And so it's not, and they would start, whoever would purchase those, would start the extraction of the mineral rights, would do so in a way that would not interfere as much as possible with the surface rights that are on the ground. And by the way, the city in their designation talked about how scientific this process was. But it should be noted that the city has not yet been approved as far as the water that's that they're being used. They have no agreement with the Department of Ecology yet for the correct use of the amount of water that's going on this particular property. I'm open for questions if you have any questions.
Has the city had the opportunity or presentation to purchase the mineral rights?
They were given that opportunity, and they said no, that they were going to dispute whatever rights that the mineral right owner had.
But the original contract said that you had the mineral rights and the ability to go to the land and take the mineral rights out.
Yes, it does. I could read it to you if you want. I've got a copy of it here, but it's...
I think we got to make sure whatever we're referencing is in the record.
Yeah, it should be on the record because the attorney for the city presented a stack of papers, and then there is a...
Mr. Chairman?
Yes.
Mr. Hall, would you mind, you were gone when this came before the planning, would you mind appealing and going to them first with this argument?
Yeah, I would like to, whatever.
I think that might be
Let
the
me
best
check.
route for all of us, so that
Okay.
you can get that ironed out at the planning board, so that
We
we,
would like to
Well,
do that. We don't...
I think there's a 14-day limit.
Yeah,
An
and
appeal
we're
from
past that.
a recommendation has to be within 14 days. Not to give legal advice, but it's
So-
my reading of our code.
So my understanding of that would be then, if we were to deny it tonight, then he would appeal within 14 days to get that process underway.
That would be appealed to Superior Court.
No, what I'm saying is a recommendation of the planning commission may be appealed within 14 days.
Right.
So we're
Not
past
this.
that. So the recommendation was never appealed, the recommendation of denial. So we're still in a closed record hearing on the CUP, but there's no recommendation. Well, they can't appeal it at this point under our code.
Not the planning commission.
At least in my view, he's certainly entitled to go look, talk to his own legal counsel about that. I'm not giving him advice about it.
They can appeal your decision,
to who?
Superior Court.
Superior Court?
Can you confirm that the information that Mr. Hall just shared with us is in this record?
It would,
The only difference was that I don't know that the city was aware that of my background, that I worked for Glacier Park Company. Much of tract, for instance, was land that we sold. We sold it was land grant properties that were originally owned by the Burlington Northern Railroad, and they decided that they wanted money to invest in another enterprise, and so they asked us to sell that land, and so for a year and a half, my job was to sell myself out of a job. So I'm aware of what goes on in the dealings on the sales of this property, and I'm one of the few that's left to do that because that was back in the 80s. So.
And Derek, you can perhaps chime in. The Frontier Title and Escrow Company does include a description of the exemptions, I believe, within the title, which is in the record.
Yes.
You know what page that is in our packet?
I can tell you where I was at earlier. There could be more than one. I only
For the
found
benefit
one.
of the audience, our packet on this is 571 pages long.
Yeah.
I had just moved it, so let me find it.
Okay, thank you.
Take me a while. I had it. So there is one of the noted exemptions accepting for underlying and surface. And that is on page, it's Exhibit 1017, Exhibit 1, page 17 of that. Can't tell what page of our packet that is. 17, page 7. No, that's not right. On page 17 of the, I think, of Derek's packet of Exhibit 1.
Maybe I'll just read this, what it is that we're reading in our packet. Exceptions and reserving. However, unto said grantor, its successors and assigns all of the coal, oil, gas, casing head gas, and all ores and minerals of every kind and nature underlying the surface of the premises herein conveyed, together with the full right, privilege, and license at any time to explore or drill for and to protect, conserve, mine, take, remove, and market any and all such products in any manner which will not damage improvements existing or made by grantee to the premises herein conveyed, or interrupt or interfere with the grantee's use and enjoyment of the premises hereon conveyed, together with the right of access at all times to exercise said rights.
I think that's probably as good a segue as any to the city's presentation on this, because that's really the fundamental issue we're dealing with here is the exercise of a mineral right holder can't interfere with the enjoyment of the surface right holder's use of the property, at least not unreasonably So, do we have any more questions for Mr. Hall, or do we want to hear from the city?
Let me just add, there could be other elements in here that were being referenced that, that I simply haven't looked at quickly, so.
Yeah.
So a question before we proceed. If we didn't feel like we were prepared to take an action one way or the other on this, could we continue this for another week or two?
You could continue the hearing, yes.
Thank you.
I also believe, you correct me if I'm wrong, you can close public comment and then come back for your deliberation as well.
As long as we don't close the closed record hearing, sure. We could hear from both sides and then take it under advisement and not close the hearing.
Any further questions at this point before we move on to
Not
the
at
city
this
of
point,
Pasco?
Mr. Hall.
Thank you very much for
Thank
allowing
you.
me to make a few comments. So.
Thank you.
Mr. Chairman, Commissioners, Ken Harper for the City of Pasco. I'm a lawyer representing the City of Pasco tonight. I want to start with a pretty clear proposition. The city did not sign this application. I mean, that's where this hearing needs to begin and end. Pasco did not participate in this application, did not sign it, does not support it. I can't be emphatic enough about that. Franklin County Code 1430-020 sub B, all applications shall be signed by the property owner or an authorized representative. What has happened here is the purported mineral rights owners have developed a conditional use permit application for a 200-acre surface mine in the middle of Pasco's 1,900-acre process water reuse facility because they hope to sell minerals to the city of Pasco to avoid the city having to disrupt the PWRF, which is a finely calibrated land application spray field, to tailor the agronomic rate of uptake for this land to the process water reuse facility users. This thing is a very, very carefully created and engineered structure. It's not just a crop circle. Contrary to Mr. Hall, I also want to point out that this is highly regulated by Department of Ecology. In your record, you have the letter of ecology dated April 12, 2023, which is the Ecology Wastewater Treatment Plant Process Water Reuse Facility Engineering Report with the approval certification. This thing has been in the works for years before we learned of this CUP application midstream in April. So I just want to be as clear as I can that this has to do more with the Franklin County Code standards of whether or not a property owner should know what's happening when somebody makes applications that are going to affect that property owner's rights. Now, I appreciate that the board has asked questions about mineral rights, and in the record that I submitted to the Planning Commission, I provided a comment letter that develops a little bit of the case law on mineral rights. I happen to know a little bit about it because I've been representing the city of Richland in federal litigation for the past couple of years with respect to Saddle Mountain, which is Mr. Maughan's business operation. And in that case, the federal district judge, Tom Rice, last September granted summary judgment to the city of Richland because he did not find that Maughan's, or Saddle Mountain in that case to be more specific, had the right to control the surface. Now, I've cited some of the case law in this, and one of the commissioners made the comment that this might be an issue to take under advisement. Close the public comment tonight, take it under advisement, come back, deliberate. I have no problem with that at all. I encourage the board to take the time to read my comment letter, look at the materials in the record, consult with legal counsel as you see fit, and make a principled decision. If you do that, I also encourage you to take a harder look at the title report. Mr. Hall is correct. At the Planning Commission level, I introduced the Frontier Title Company title report for this particular parcel. I did that because I wanted to go beyond the assessor's records. The assessor's records is also in everything I'm going to quote is in your record. I know the rules. The assessor's records under ownership state owner's name, City of Pasco. Ownership percentage, they state 100%. That's the assessor's records. That's not necessarily a chain of title, so we commissioned a title report. You have the title report. In the title report, it is true, there is an exception in the reservation that relates to minerals. Your county administrator read a portion of that deed, but let's take a closer look at that deed. That deed is a reservation of minerals. There is nothing in this title commitment that indicates who that reservation flowed down to. Now, Mr. Hall said that it's his clients. That's not in the record. You can study this title commitment as long as you wish, and you will not find anything that connects any reservation of mineral rights back to Mr. Hall or the folks that he represents. There's nothing in this title report that references the Mons. There's nothing in this title report that represents Saddle Mountain. That's important because title companies don't always track mineral deeds. We don't know who's got the mineral rights. Now, we could take it as an article of faith that Mr. Mons' business has them, but the record doesn't show that. Even if it did, that's not an issue that has to be decided by this board. Your obligation is to make a principled decision of your conditional use permit criteria. It's not to gauge what is or is not the chain of title on mineral rights that are frankly open to interpretation anyway. And without repeating myself, I said earlier that at least one federal judge has found that Saddle Mountain does not have the right to control the surface because of the status of Washington mineral law. I don't want to belabor that. I will just say, though, that the current position of the Washington Supreme Court is that a mineral rights deed can only be interpreted based on a full understanding of the surrounding circumstances, and that a mineral rights deed that purports to convey all minerals of any kind whatsoever will not be enforced according to what it says. The reason why is because if you claim to have the rights to all minerals of any kind whatsoever, then there really is no surface estate. Because you could just mine everything and say it's all part of the minerals. And what we're dealing with out here is things like common sand and gravel. We're not dealing with casing head gas. We're not dealing with uranium. I mean, we're dealing with common sand. That's the surface. So my argument to Judge Rice, and certainly my argument in court if we get there, is going to be that even if Mr. Hall's clients could demonstrate that they can link up to this reservation of minerals, even if they could do that, and even if that were somehow germane to the Board of County Commissioners' criteria for review tonight, it is not my interpretation of Washington law that all minerals of any kind whatsoever gives them the right to control the surface. If we extract minerals and move them from the site, sure, that's a different question. If they can prove they own them and we remove them from the site, we could have a problem. But if we're trying to exercise our surface rights the way we have for years and years and years, then there is no argument in my mind that they have the ability to go onto the surface and dictate how we can continue to use them or obligate us to purchase those. So, Commissioners, I appreciate your attention. I don't want to belabor my time. I know you've got a busy agenda on closed record appeals tonight or closed record hearings tonight. Can I answer any questions for you? I'd be happy to do the best I can.
So the original contract that they signed says that they did not buy the mineral rights.
I will agree that there was a reservation of mineral rights that is associated with that title. Yes, I will agree with that. Now, I can't speak to the contract because I don't think that purchase sale agreement is in the record, and so I don't know what the purchase sale agreement says, but I know what the title commitment says. And the title commitment shows that there is a reservation of mineral rights.
Who has the original contract?
I don't know the answer to that. I suppose it's somewhere in the archives of the city of Pasco, but I don't know that. I apologize.
I guess my question would be if you knew this would arise, why would you move forward with a processing water treatment on top?
Well, because we understand what Washington law is on mineral deeds. I mean, there would have been a decision made that even though we don't own the minerals, we don't need to own the minerals because we don't plan to extract minerals. We don't plan to mine. We don't plan to disrupt their mine if they had one. We're going to use it for farming. Other questions?
I have no other questions.
I encourage you to follow your Planning Commission's 6-0 recommendation to deny. And again, I appreciate your attention. I thank you very much.
Thank you.
So,
question? Yes.
Questions from Commissioner Baumann.
So while I do appreciate what you said, it does say that it is reserved for successors or assigns, and I recognize that that's open and there may be some question there. but it does say access to at any time they please. I mean, it says that in very plain language. However, that being said, I do agree with you that it is very clear in Franklin County Code that it says the city of Pasco has to be a party to this process. And based on that, Mr. Chairman, I am not in favor of granting this conditional use permit.
So the city of Pasco is issuing the permit?
Your entity would. Franklin County would issue the CUP.
Okay, no, as far as, it just seems like there could be some conflict of interest if the city of Pasco is the surface owner and they're involved in the permitting process.
They are not. This
Well,
will be
I don't
county.
believe it would be,
Okay.
Commissioner. Yeah, yeah.
This is ground that I believe approximately 5 miles from the city limits.
That's correct.
Mm-hmm.
Yeah, it's in the county.
I'm very familiar where the property's at, and I'm familiar with the water that they're putting on it.
Simplot.
Yeah. Questions? Commissioner Didier? All right, thank you.
Okay, thank you.
At this point, close the public or comment.
We could, if they want to continue the closed record hearing, we could, or if the board wants to entertain a motion, they could do that as well. But if they want to continue this hearing, I would continue it to a date certain, perhaps a week or whatever the board decides to do, so the parties have notice today.
I'm in favor of taking action tonight. It's pretty clear for me.
As I am too, and the, Mr. Hall can take it, he can go to Superior Court if he chooses, so I'm ready to take action.
All right. So at this point, I will close the closed record hearing and entertain a motion.
So, point of clarification, so approval of this resolution would deny the conditional use permit. It would accept the recommendations of the Planning Commission and deny the conditional use permit. Is that accurate?
Yes.
So based on that, Mr. Chairman, I would move for approval of Resolution 2024-0199 as presented.
Second.
There's been a motion and a second. Any further discussion? Hearing none. All those in favor of the motion signify by saying aye.
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 Aye. Motion passes. We will now move on to the open closed record hearing, Resolution 2024-0200, closed record hearing, CUP 2024-08, Lone Crow Meat Processing Facility, presented by Derek Bratton, Planning Director.
Trying to figure out when my cursor went. Okay, must be down there somewhere. Fine, we'll do it the old-fashioned way. Thank you, Chair. This is a conditional use permit for Lone Crow Meat Processing. It's a cattle harvest, a request to site a cattle harvest facility out in the AP20 zone. So currently there is no citrus address assigned to the property. Its parcel number is 122-700-015. Zoning is AP20, agricultural production 20. Comp plan's agricultural. Property size is approximately 92.85, but the facility is not intended to take up that amount of area. Location is west of US Highway 395, east of Kent Drive, north of Ferguson Lane, and east of Langford Road. As mentioned, it's for the development and operation of a cattle harvest facility. The property owner is Nita Lundgren. The applicant is Cody Hoseth of Lone Crow Meat Processing. Area to be used is approximately 6,000 square feet for the proposed facility. However, that does not include the area for the septic. That's just like where the actual activity will occur. There will be some ancillary elements such as the lagoon and stuff that would be outside of that 6,000 footprint. This is the subject area. And this is roughly, and we'll see that better in a later slide, but that's about where we're talking about. I think I might have been a little south there, but site photos. And then here's the site plan. And so we're looking to locate right in this area. They're open to eventually get up to around, and they're applying for the right to operate a facility that's basically somewhere between 1,000 and 2,000. Usually in these cases, we would say they're going for 2,000. It won't happen overnight, but in a conditional use permit, we set the head count at the maximum that we want them to achieve before coming back to us for another. So in other words, what we want to do in the CUP, if this is going to be approved, is you want to set that head count. If they exceed that head count, whatever the head count you want to set it at, they have a right up to, they have rights to a certain amount, but at these levels, and I apologize, I'm drawing a blank right now as the number, but what they're requesting is up to a 2,000 head count. If they exceed that, they would have to come back for an amended CUP. If we set the number lower and they exceed that, say you set it at 1,000 head. So whatever head count you want to do, if you're going to, so keep that in mind if you are seeking to approve this, that you're going to want to establish the head count, because anything, if they can do less, but if they go over that amount, they need to come back to us for an amended CUP.
And what is the time frame for that head count?
That's generally as market dictates. So, that's a lot of head of cattle. So I don't know when. I don't tend to speak to the applicant's business operations or plans with regard to those aspects, just because they're the ones that actually are they know what they
Head count at any given time?
The head count, if you set it at 2,000, yeah, they could show up with 2,000 cows. Or
This is
not cows.
over the space of 1 year.
Yeah, in
That's
a
the
year.
question, yeah.
I'm sorry. I misunderstood what you were asking. So yes. No,
right,
not in a day. The facility, I don't know if the
You're gonna
ground
need
would
more space if
accommodate
that's a day.
that. The 6,000 square foot definitely wouldn't. I apologize. I didn't mean to confuse. So, on or about May 30th, staff sent notices to technical agencies, property owners within 1 mile in the Franklin County Graphic, posted a pending land use action sign on the property on May 30th, and made a SEPA determination of non-significance in the SEPA register as file number 202-402-318. And this is a request for the construction of a USDA certified cattle harvest facility. As mentioned, it's proposed to have a 6,000 square foot facility along with the septic system and an affluent lagoon. And because of Franklin County Code 1710040, a conditional use is required for this type of facility. Frankly, actually, it's required in all our zones, even our industrial zones. Benton Franklin Health District, they were going to need to get the permit for that, for their septic system. They will need to figure out some way to get a public water supply. That is between them and Franklin District Board of Health to work out. The construction and use of a lagoon for effluent must be permitted, construction and its use approved by the appropriate agencies, and the appropriate permits from, this is a little, appropriate permits from USDA must be obtained for the use as a cattle harvesting. The inspector, I mean, that's basically you build the facility, then they come in and they go, does it meet muster? Let us tell you how to tweak it until you do. So they're not going to have those permits at the time of permit issuance, building permit, but they would have to have those permits by the time they start operating.
Our portion of
And-
this would be to potentially approve the site, and it would be permitted and oversaw by the Department of Health and the USDA.
And or the Department of Agriculture, depending on which aspects and elements we're specifically talking about. But yeah, most of the operations out there would be observed and monitored by agencies outside of the county. What we're doing is stating basically permission to proceed. We would not be the ones that go out there and determine whether or not that thing meets, that's not our purview. Our purview will be, are the buildings correctly built? Do they meet the requirements as provided by engineering and or the IBC? These types of things. And then also proximity or any issues associated with that, that the board may have with regard to these types of activities. Location. The actual operations, how all that stuff, that's handled by agencies outside of this, at both the state and federal, and some local, regional agencies will be the ones that monitor those different aspects and ensure that the operation is correct. If it were to fail, or we would, receive notice from one of these agencies, then the county would then take corrective action, potentially including up to revoking the CUP for lack of compliance with the required conditions. We sent that out to USDA. They didn't have any, well, the Farm Service Agency, which is not surprising. They didn't have any comments. They kind of look at bigger stuff, generally. They'll need an access permit. Any utility extension crossing the roads will be addressed at the time of application. There's no addressing. Once the building gets up, that will determine based on the access and location of that structure on the property will determine the addressing. That will have to be in place at, basically when they start combustible, any combustible build, or they have the potentiality of injury on the site, depending, generally earthwork, you don't necessarily have to have it in, but the time you start erecting the building, it has to have the address. They'll need a building and grading permit. They'll need to comply with the Franklin County Rural Fire Code, and they'll need to abide by the odor and fly control plan due to the inability to really control what happens as far as smell and odor. They'll have to figure out something to do with that effluent pond, because if it's not maintained correctly, it can get a little ripe. I think that's an understatement. CLET and then Department of Ecology had comments that are included in your packet. And then I apologize, this should say, well, yeah, anyways. The proposed use is in accordance with the goals and policies of Franklin. This is not right. This is not the, this is the presentation. These conditions were what staff recommended to the Planning Commission. The Planning Commission recommended denial. And we prepared. Tell me I didn't bring those. I don't have them.
It starts on page 3 of our packet tonight, I believe.
Yeah, and
Page
I-
2 of what
I
you're looking for.
unfortunately don't have it. So what you have in your packet are 2 resolutions. One is A, if you deny, correct, if I have that. Do you have it? I appreciate it. I thought I'd printed them out, but I just have my plan commission. What's that? Well, I sent a new one that was supposed to be different than that. Oh, God.
Resolution A is recommendation of denial. Recommendation B is recommendation for approval
Okay.
in our
okay,
packet tonight.
Okay. Yeah, there was an oops when I initially submitted it where the front page on one of them was wrong. Teresa caught that. Okay. But that's not what's up on the board. All right. But unfortunately, I do not have the slides with the planning commission recommendation. Basically, their recommended findings of fact are what are provided in the denial resolution. So, and I gotta make sure that I am. Wrong one. I'm gonna start bringing my tablet because this works better. I just have to make sure they're the right one. Okay, yep. So, the planning commission recommended findings of fact are as follows. The proposal is in accordance with the goals and policies of the county development regulations and applicable comprehensive plan. Franklin County Comprehensive Plan, land use designation as agricultural, and the zoning designates the land as agricultural production.
Please speak into the mic.
I'm sorry, I didn't realize I'd moved that far away. Constructing a cattle harvest facility requires a conditional use permit, and the applicant has applied, so it meets that. However, the planning commission concurred with testimony given. Okay, the proposal will adversely affect public infrastructure. The planning commission concurred with testimony given that the road serving the property is poorly suited for having a cattle harvest facility. This is due to concerns about having commercial semis utilizing a gravel road that is not properly maintained. The proposal will not be constructed, maintained, and operated in harmony with the existing or intended character of the general vicinity. The existing or intended character of the immediate area is agricultural. Planning Commission concurred with testimony given at the hearing that the cattle harvest facility would negatively affect nearby properties, would not be in harmony with the existing character of the neighborhood. This is due to the proximity of the nearby homes and the potential for children seeing cows being butchered. The location and height of the proposed structural and site design will not discourage the development of permitted uses on property in the general vicinity or impair the value thereof. The proposal shall not exceed the maximum building height of AP 20 zoning district, which has a maximum height of has a maximum building height of 35 feet. The operation in connection with the proposal will be more objectionable to nearby properties by reason of noise, fumes, vibration, dust, traffic. Planning Commission concurred with testimony that at the hearing that the fumes from the cows, along with potential for the spillage of blood, would be objectionable to nearby property. Proposal will endanger the public health, safety, or general welfare if located where proposed. The Planning Commission concurred with testimony given at the hearing that the location of the cattle harvest facility nearby residential homes would negatively affect the general welfare of nearby residents. This is due to increased truck traffic, commercial truck traffic, proximity of nearby homes, and potential of children seeing cows being butchered. So those are the Planning Commission, and those are as provided for in Resolution A. Resolution B, I don't trust this slide, so I'm going to use exactly what's in it. So, Resolution B is if the board should choose to approve the application. These are the planning department's recommended to what they recommended to the board, planning commission. The proposal is in accordance with the goals, policies, of county development regulations. Franklin County Comprehensive Plan, land use is agricultural. County zoning code designates the land as agricultural production 20. Constructing a cattle harvest facility requires a conditional special use permit, and they have applied for the special use permit. The proposal will not adversely affect public infrastructure. Franklin County Public Works Department has determined that the proposed use will not have a significant impact on the county road system. The proposal will be constructed, maintained, and operated in harmony with the existing and intended character of the general vicinity. The existing and intended character of the immediate area is agricultural. The proposal will not impair the ability for agricultural activities to continue, nor will it have a negative impact on the intended character of the general vicinity. Odor complaints shall be addressed by the applicant and minimized as possible. An odor and fly control plan will be required. The location and height of the proposed structure and site design will not discourage the development of permitted use on property in the general vicinity. The proposal shall not exceed the maximum building height of the AP20 zoning district, which is a maximum height of 35 feet. It will not be more objectionable to nearby properties by reason of noise, fumes, vibration, dust, traffic. And the proposal will not endanger the public health, safety, or general welfare if located where proposed. The proposal will not have a negative impact on public health, safety, and general welfare. It is required to comply with the health district and public works standards regarding health and access safety standards for the proposed use. And it's required to meet or exceed all sanitary requirements for the operation of commercial cattle harvesting facility as required by any licensing or approving agencies. There are also suggested conditions of approval. If that's the direction the board is leaning, I can go into those then.
Any questions for Derek Bratton?
Chair?
Yes. Chair recognizes Stephen Bauman.
So a couple of questions for you, Derek. On there, talking about semi-traffic, do you have any idea how many trips per day this site or this facility would generate?
Not off the top of my head, but
Well, even at 2,000 head per year is only 40 cattle per week.
That's what I was doing. I mean, that's one
they're
one
gonna
stock
be
trailer.
panel truck size, I would assume. But you know, if things go, I mean, have you ever heard of a business not wanting to improve? So if he's kicking it and he's really going good,
That's the point. Is at wide open, that's one stock trailer per week. As far as that's one big load, or 3 or 4 pickups. So that's really not a large number. And then you made reference to children being concerned with the harvesting of cattle and blood being spilled. This is a fully contained indoor facility. Is that accurate?
that's my understanding. Yes.
So those things would be irrelevant to the concern for this facility, because that wouldn't be you wouldn't drive by on the road and see any of those conditions. I don't have any further
All right.
questions.
Commissioner Didier, do you have any questions or concerns?
The pond that's going to be created will be lined, correct?
Yes. That's where because there's certain standards. I don't know all of them off the top of my head, but yeah, that would all be. We can't have that getting out. Those ponds are different than the retention ponds for irrigation. That's clean water. That stuff has to be locked in. It's just like a dairy facility. Those affluent ponds, they have to be lined, monitored. I think they even get tested periodically, but I don't know enough about it.
So currently, he's working underneath Washington State Department of Ag, correct?
That's our understanding, yes.
Yeah. And I think everything's arose because this is right next to my farming operation. So I drove by it yesterday and took a look at it. And if it would have been removed further from the road, if they would have been further down in that canyon, I don't think there would have been anybody upset. But it's right by the road. I drove by it. And when I drove by it, I know the smell of death and butchering because I have it done on my farm. and it was pretty prevalent. So I think if we would have just started off with this further away from the road, I think we wouldn't have probably had a problem. This is going to be a building where they won't see the animal killed,
That's my
in,
understanding.
or nothing. It's just like what goes on out here at Tyson. It comes in and there's going to be a chain of events that happen, and
Yeah, the activity shown in the pictures, that was under a different licensing scheme.
Right.
He's seeking to, according to, our information is that he's trying to elevate to a USDA facility because they indicated that that's a need in the community, as well as, just as the better quality. There's more eyes on what he's doing.
yes, under
those types
USDA
of
rules,
things.
there has to be a USDA inspector there when they're operating.
Yeah, so.
And so then all of the remnants of that butcher will be discarded in a right way that we won't see in, like we've seen in these pictures.
That would be my understanding.
Yeah, because the pictures, that were asked not to be submitted were in our packet, and reviewing them here, I see this one picture of all the crows. It's not a lone crow. There's a pack of crows there, so, I mean,
Regarding comments and staff, we just, if they show up at the hearing with things, we don't feel that it's a good idea for us to try to pick and choose. So
Right.
unfortunately, you guys kind of get
Public
sometimes
record.
we'll get the fire hose effect with information, so.
definitely needed in our neck of the woods. I just wish they would have started off in a better way and been more concealed, because it is a little bit alarming for the neighbors to, and this whole aspect of children seeing that was my objection to the Mirror Ministries putting that right next to one of our butchers out there. They put that facility right next to him, and I said, how therapeutic is that going to be for those girls that are trying to heal to see that happen right before their eyes? So I understand, and we definitely need it. So
If I can interject, Commissioners, Mr. Johnson just handed me a quasi-judicial proceeding document from MRSC, which is something we should be following in quasi-judicial proceedings, which is the appearance of fairness doctrine.
Yep.
So the board in this instance is acting in like a quasi-judicial capacity, so not a legislative one. What that triggers is the appearance of fairness doctrine, which basically means we want to make sure that the proceedings are fair. Some counties will have their own codified procedures for that, but at a minimum, we want to make sure that there's no self-interest. So MRSC has some suggested guidelines that we follow. For example, I'll just go through them. If any member of the board has any interest in the property of the application, or they own any property within a certain distance, they would want to put that on the record. If they stand to gain or lose any financial benefit from ruling on this permit application, whether they can hear and consider the application in a fair and objective manner, if they've engaged in any ex parte communications with proponents or opponents of the application. If so, they can state those on the record, and the interested parties will have an opportunity to hear and rebut those communications. So that doesn't disqualify you from the proceedings, just because constituents are going to reach out to their electeds to talk to them about things that are important to them. You just have to put that on the record and say, look, neighbor reached out to me, was concerned about this. I just want to put that on the record. So what that does is it gives the opportunity of the applicant to say, well, I've got something to say about that. Here's my response. The last thing is that we could ask members of the audience if they want to challenge whether they think the board is disinterested. They could say, well, I don't think that, Commissioner so-and-so is disinterested because I know that, their brother's the applicant, something like that. So that's a typical script that you'll see boards run through for quasi-judicial type of hearings. So if the board wants to at this time, we probably should have done it at the outset, so thank you for that, Eric, I appreciate that. If the board has anything they want to disclose about this hearing, they could do so now. What that would trigger potentially is that if you did have an interest in it, you would just recuse yourself from that hearing, is how that works.
Mr. Chairman,
Yes. Commissioner.
so as a cattle farmer and a local resident of that area, this would benefit me because I may use it for slaughtering of my animals. And so this is something that would help my operation. So I'm gonna lay that out there right now.
So, Mr. Chairman,
Yes.
as a rancher myself, like Mr. Didier, I have no interest in the property per se, but down the road, it would likely be a place that I may or may not, utilize at some point. I did go to the site. I've been by it a number of times, different times of the day to try to understand and appreciate what's going on there. I have talked to the applicant, made his acquaintance through this process, and listened to what his concern and what his thoughts was of the process. That was one of the reasons for the question about the blood and the concern for children seeing cattle harvested, because my understanding was that it would be a fully enclosed and clean, sterile USDA licensed facility. And so that's all I have.
As a cattle rancher, I have no ties to the facility. I've seen the facility in Connell. It's clean, sanitary. Would I ever use the facility? I mean, at this point, I have no plans to.
And I think it would have to be a direct sort of financial relationship with
No.
the facility, not the prospect that you might utilize it at some point, because then that would potentially keep you out of decisions on all sorts of things, like, a Walmart Supercenter comes in, you might shop there, so, that sort of thing. So I don't think it's that broad. It has to be more of a direct financial interest in the project. But it does sound like Commissioner Baumann may have had some communications with the proponent. Is that accurate?
I met with them on the site, listened to what they had proposed to bring to us here tonight, and that is what I find in this packet.
And do you believe that communication has left you in a position where you can't be impartial?
I do not believe that has compromised my impartiality.
Okay. We have members of the public here who commented on I know there were members of the public that were against the siting of the facility. Are any of them present? That would be the time to ask them if they, or I guess any member of the public really could say that we don't believe that
For the record, all parties that provided contact information at the hearing were provided notification, specific direct communication regarding this hearing.
Are there any online?
It's hard to hear you, Derek.
Oh, I'm sorry, they were provided, all commenters were provided, everybody that appeared in the, either submitted in writing and or appeared in person during the public hearing were notified directly of this meeting tonight.
All right, thank you.
Mr. Chairman, I don't know if we need to see if there's anyone online that might also.
Do we have any callers online? All right, thank you.
So I guess we'd ask the public one more time, if anyone here feels like they feel the board can't be impartial on this, if they could state so now or forever hold your peace. Okay, haven't heard anyone.
All right, thank you. Any further discussion?
Mr. Chairman,
Yes.
I would just like to ask, what is the, I guess with the temporary, are they going to continue to use the temporary at this location, or are they going to wait until the building is built?
Did you come up?
Please come to the mic. You're not gonna butcher there no more?
No. No, we haven't been butchering there for a while, so.
Good.
this is the reason why we're building this building, so
Yes.
we don't have to do that anymore.
Thank you. That would probably be best.
Right.
Thank you.
All right, any further questions?
Is this,
Discussion?
is this his opportunity to share with us inside of a closed record hearing?
Yes.
As long as it's on the record.
As long, yeah, as long as he doesn't speak to matters outside of the record.
Okay, my name is Sam Cosillo. I entered in a partnership with Long Crow about 6 months ago. And the reason we're doing this, I'm asking the board to deny the motion to deny. Did I say that right? Yeah. And the reason we're trying to do this is because our shop in Canel is now USDA certified. It took us about 6 months of process to get there. And this Monday, we started processing USDA beef. The community, as you guys can see, needs this, supports this. We don't have a place to slaughter USDA cattle in our county at all. If you have some cattle, you're a small farmer or a small rancher, and you want to sell meat to your neighbors, you can't. You're not allowed. And that, to me, is just a little bit insane, since we are Franklin County and we're a right to farm county. We have beef all over the place that we can't consume, that is our own. We have to bring it from somewhere else. The beef that you consume in the supermarket is not grown here. Yeah. And our beef is here. We can produce it here if you allow us to do this. And just to get your mind at ease, 8 head a day slaughter takes 2 guys to do, 4 hours a day. That place is gonna run 4 hours, it's gonna be clean. The cattle are gonna be sometimes walked there from our feedlot. Sometimes they're gonna come in a gooseneck trailer, and we're gonna haul off carcasses once a week. That's the traffic that we're talking about. It's just an enclosed building that has absolutely no impact on anything. Our pond will be lined, like you were asking. Mm-hmm. We will have our offal will be hauled off to a compost area that we have on our feedlot, about, down by the feedlot, and which is what the state of Washington wants. They don't want offal on landfills, so we're gonna compost it all with manure and spread it on fields and grow products again. So we're asking to do things right under the supervision of the USDA inspectors. What happened in the past was it was under the law, but it was just visually ugly, if you may. But we're hoping to fix that. We feel that the Planning Commission decision was a bit emotional, and they didn't follow. They told us they were technocrats, is what they called themselves, and then they kind of went against it. We didn't understand why. We also, my ignorance, I didn't know, or I chose not to stand up here and fight it, because I didn't want to fight with our neighbors. We want to be good neighbors with them, which is why we approached them in person before and explained to them all what we're trying to do. And we intend to do that in the future too. We have no ill will to them at all. Any questions for me about the process?
Mr. Chairman.
Chair recognizes Commissioner Baumann.
So in this, there's 15 proposed conditions of approval with this. Is there any of those 15 that you have concerns about or don't feel that are proper? You feel like all 15 of them are acceptable to you through this process?
Yes. We reviewed them, and everything is already in our plan to do, because it's better practices and we have to. To be USDA certified, you have to go through all that. The USDA is not going to let you slaughter one animal unless everything is in place.
No further questions for me.
All right, questions?
I have a question, but it isn't on the record, and that has to do with their composting. Is that permissible to ask about the composting if it isn't in the record?
Is the composting referenced in the record?
I believe it is. When I read through it, they said they were going to compost the.
Sure, I think you can ask it.
Or do you have an apparatus to turn your compost every so many days, because that's the way you really get compost to work right? Have you got that device, or are
We
you
don't
gonna
have
get-
it yet, but we will get that.
You will get
We
that?
just went to a WSDA class in Moses Lake.
Okay,
We're learning the process. We already knew the process, but we're learning the process for specifically for USDA slaughter plants. And we got that process, and it's still working. It's a work in progress, but we can't compost unless we do it right either.
and they
It's
inspect,
also regulated.
they inspect that, okay,
Correct.
good. All right, thank you.
Correct. So, you're welcome.
All right, well, thank you.
Thank you.
We open it for public comment for
Yes.
anybody opposed.
The only people who can comment in a closed record hearing are persons who participated in the planning commission open record hearing. So it would be limited to those individuals.
And/or their agents.
But they already asked if any of the people here that objected, none of them are here.
Okay,
Either for or against, right?
Doesn't look like it, unless.
yes,
Go ahead.
please come forward.
Just want to say that our conditional use permit cannot include the USDA certification, because that doesn't happen until the building is built,
Right.
right? So I just wanted to clarify that. Yep.
But it will be a USDA permitted facility.
Right. Basically, they're going to come in. The idea would be that they know everything they need to do. and
They
they'll
don't get to operate without the USDA permit.
They'll pull those permits, then they won't get their final sign-off, I guess you could say, from us until we know that they've got that approval from USDA.
The chair recognizes, come forward.
So basically what Sam was getting at was that in the 15 conditions of approval, one of them is the approval of USDA permits. We would like that to be removed because the USDA is not a permitting regulatory agency. They're just an inspection agency. So what we don't want to do is go into the county to get building permits or Benton Franklin Health District and then them get hung up on, well, where's your USDA permit? It doesn't exist. There won't be one. So
Yeah, I would concur that that's that it shouldn't be typed that way. Because as again, that would be like saying, because remember, this is a permission to proceed. And for them to have USDA permits in advance of the construction of their facility is not possible. So that will need to be,
Do you know which one that is? I'm looking here and I don't see that
See it either.
language.
I don't think it's in, I don't remember it being in the resolution.
I don't see it in the,
I think it was more in the, some of the, okay, hold on, finds of fact. Or no, I mean conditions of approval. Health district.
Comply with DOE, comply with Benton
The
Franklin Health
appropriate
District.
permits from the USDA or Washington State Department as applicable must be obtained.
I see that, D.
So D should be, 2D should be, and it says as applicable.
Yeah.
So there's that caveat there that kind of says, basically, if they're needed, you got to do it. So it is not stating that they have to have
As
it.
applicable. That particular one wouldn't be applicable.
Yeah, I mean, it would, because that's from the health department, that's their conditions, and that would have some, most likely to do something with their final approval of the facility. Like, the health district wouldn't be able to, I don't know, potentially, they may not be able to sign off on it until all those ducks are in a row. Because
Yeah,
remember,
that-
these are comments from them for their needs with regard, and what we do with agency comments, we just forward them through. We don't generally, because this is something they need for their stuff. Also, so that has nothing to do with their build. This has to do with getting the final sign off from Benton Franklin Health District, those comments there. And the as applicable also caveats it to where if you need it, then you have to have it. But if you don't need it, then you don't have to have it. But it depends on a lot of variables as to what's going to trigger the different stages, permits, and licensings. It's thresholds, things like that.
Yeah, reading that, I don't think that'll cause any issues because it's underneath Benton Franklin Health District and it says where applicable, so I don't think that would apply in this instance.
I would recommend maintaining that just in case a specific situation arises such that that would be triggered as far as
become
the
applicable.
as applicable selection. If it's not there, we could have an issue if some bizarre hypothetical scenario I can't even think of occurred. But if you're going to approve it, then I would definitely, you want to have, the conditions, set your parameters that they need to meet. If you're going to deny it, you don't need to set conditions, you just have to have the findings of fact.
Any further discussion? Hearing none, I will now close the open closed record hearing. And entertain a motion.
So, Mr. Chairman, let me get some clarification here. So, approval of Resolution 0200 would approve the conditional use permit. Is that accurate? Option
B.
Option B.
So, Mr. Chairman, I would move for approval of Resolution 2024-0200, conditional use permit, Option B, to approve the conditional use permit for Lone Crow Meat Processing Facility.
I second.
It's been a motion and a second. Any discussion? Hearing none. All in favor signify by saying aye.
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 Aye. Motion passes unanimously. Moving on to the open closed record hearing, Resolution 2024-0201, closed record hearing, CUP 2024-09, graph presented by Derek Bratton, Planning Director.
Thank you, Chair. Yes, this is a request to cite I've been working here 6 years, and this is the third one I've gotten, or the second one I've gotten this year for this. The siting of a accessory structure in a front yard. I knew 24 was going to be different. It's always different how it's different. So, as mentioned, it's a conditional use permit for the siting of, whoops, well, I've got it here, but you don't have the pretty version. Okay. Harpster land, or conditional use permit for the siting of a accessory structure in the front yard of a property. The address is 2270 Dent Road. Parcel number is 126230063. Zoning is Rural Community 1, RC1. Comp plan is Rural Shoreline Development. Property size approximately 4.62 acres. It's generally located east of the Columbia River, west of Fraser Road, west of Concord Crest Lane, and north of Pelican Lane. The reason why this triggered the need for the conditional use permit is the placement of a accessory structure in the front yard is limited in RC1, well, basically most zones except for the RR zones and the AP zones. In order to do that, that's because in those smaller 1 acre zones and stuff like that, they start developing more of a almost subdivision or neighborhood look, suburban look and feel. And a lot of these types of requirements are based on aesthetics and maintaining consistent lines. So the structure itself is approximately 4,500 square feet. And they have the site access, location of single family dwelling, location of proposed accessory building, and the location of existing proposed septic system. This is a subject property. So the key thing to know about this property is you see this white, basically from there down it's straight at about a 45-degree angle. As you can see, that's a lot of his land he doesn't get to really use for anything other than to run up and down a hill. So they're seeking to place it out here. Actually, I don't think that road exists anymore, if I remember correctly. But anywho, they want to put it out in the front because their back is a pool deck area that really runs right up to that hillside and just drops. So, this is a more formalized site plan. So this is their designated front yard because this is where their access is. Well, actually it's there, but the orientation of the building, stuff like that. Front yard placement, their access comes off over here. The house is oriented that way and the river's over here.
Derek, where exactly are they building? Is the darkened spot?
Yes, this is the proposed new structure location.
Okay.
And basically, I mean, I would say there's some side yard over here to some degree, but much of this area is done in concrete and a pool and stuff like that. And it literally, that concrete edge just drops right off. So here's some pictures of the property. Those are the assessors. It was, that property was in a build for a while. This is more what it looks like today. Well, not today, but on or about June 17th. So May 30th, the staff sent notices to technical agencies. Property owners within 1/2 mile, which is the notice radius in the shoreline area, and the Franklin County Graphic posted a pending land use action sign on the property on June 17th and made a SEPA determination of non-significance, filed as SEPA registry number 202402320. An approach permit, agency comments. Approach permit will be required to access Franklin. They already have that. However, because of the valuation of the structure being proposed, it triggers an automatic need for another one. So it's always technically included as a comment. However, most of the time in these types of situations, the place is so new, it's pretty obvious that they're going to be approved, and the access going in should meet current standards since it's a current build. And then, again, utility extension crossing the roads will be addressed at the time. So Benton Franklin, the health district hasn't received the application to review or permit the lot for an additional on-site sewer. Again, though, in this case, just like the last one, or actually all three, this is at this point, they're asking for permission to proceed. They don't want to go through the cost of having the health district analysis application, all that stuff. There's money involved. If they're not going to be able to move forward, but there's no point in getting anything from the health district regarding a second septic system. The reason for the second septic system is that most likely they're going to have a restroom or something like that in that building. It's very common to have sinks, maybe even a shower in a shop or a garage, so you can clean up and keep your dirt out of your house, because it's a nice house. So prior to their pulling their actual building permit, they will have to have the on-site sewer application and all that paperwork, just like anybody else who's seeking to build something that may need that. So they'll have to bring that as part of their application for the build. PC recommended findings of fact is that the proposed use is in accordance with goals and policy of the county development regulations, will not adversely affect public infrastructure. It'll be constructed, maintained, and operated to be in harmony with the existing or intended character. This structure also meets what we call the 1680 rule. Please don't ask me why we use 1680. I don't know where that number came from, but if you hit that point in the square footage of your structure, then your roof materials and siding materials and color must match the primary structure so that it looks like it's part of the build. That applies for anything that's 1,680 square foot in these zones. The location and height of the structure and site design will not discourage the development of permitted uses. Like I just said, it'll blend in. Operation connection will not be more objectionable. This is an area of either open space and or houses. That's pretty much all that's out there. And along with some we're getting fewer and fewer, but there are still some active farms in that area, but they're starting to go away. And even a lot of the ones that are currently active are in the process of being converted to potential subdivisions. And if it hasn't already been done, it probably will be over the next 5 years. The proposal will not endanger the public health, safety, or general welfare if located where proposed. In addition to our standard CUP language, the applicant shall comply with requirements of the following agencies: Franklin County Public Works, Benton Franklin Health District, Franklin County Planning and Building. And I do have a, suggested motion, and I'm happy to answer any questions.
Questions?
So Derek, we've seen, I think this is the second one.
Yeah, I haven't had a single one the whole time I'm here, and then I got 2 in the last 3 months.
And you were talking at the last one that we need to revisit this and maybe make this easier for the people who want to build a house for their parents so they can live closer to them.
Yeah, we are doing that as part of the zoning code update. However, we can also expedite any aspects of the zoning code that the board desires us to address. As long as we have a vote of the majority of the board directing us to do that, we will kind of maybe pull out specific areas of the code if that's desired to hit those specific items. Yes, staff does think this is a little, okay, this one, these types, I'm not so, I can kind of see that, the aesthetics thing, whether or not you want, the house, but the accessory dwelling units, the height deviations, it's a lot of hassle, time, and energy for both the applicant and the county to process these applications that really don't have much impact on things. So we will be proposing, as part of the zoning code update, significant modifications and changes to the processing associated with those things. Or, again, as I stated, if directed by the board, we can start moving on any aspect of any parts of our codes. And
You have it
bring
ready
you
for next
those.
week?
No.
When do you anticipate?
Anytime, any changes of our code, though, it's going to take 90 to 120 days due to the fact that you got to have hearings, you got to have 60-day review by the Department of Commerce, and I think there's a new agency we got to play with too that also has 60 days.
Can't remember, but you can only amend that comprehensive plan annually.
Right.
So you
No,
get
I'm
one,
talking about the zoning
you
code.
have the zoning code.
The zoning code we can amend whenever we want. What we're talking about here won't affect it's our process that's in the zoning code. We can do that whenever, the board can do that whenever the board desires. Comp plan, yeah, we are very limited on, and right now we are not going to be opening up for our annual amendment process on the comp plan because we're in the 2-year update. So basically, we will do a call out, but it's not going to be that annual process. They'll submit them as part of this comp plan update.
So my question then is, to alleviate more work for you and more cost to the county, maybe this zoning should be done as quickly as possible.
Again, we get two commissioners directing me, off I go. I need to hear it.
I think that I've been vocal for the last 8 months that I would like to see this updated, so my position has not changed.
So I'm hearing I've got at least two commissioners seeking, and what you want me to focus in on is which aspects of the zoning code? The
one we're going over tonight.
This placement in the front yard? Okay.
So
What about accessory?
Accessory dwelling.
Okay. this is not accessory dwelling. This is for the placement in the front yard. But what you're primarily concerned with, or at least is the housing aspect, and basically allowing for some sort of mechanism as permitted by right. It will take me a couple weeks to come up with language. Then, once I get that language right, I can submit it out. But
Okay.
I can shoot for trying to get that done before the end of the year.
That sounds good.
By the way, Derek, I think that 1680 rule is coming from restrictions on regulation of manufactured homes. So that you basically cannot regulate manufactured homes in a way that violates HUD standards. And so I think when you're getting below that 1680 number, you're getting in the realm of potentially so if you said a manufactured home has to meet the characteristics of the other house, that might effectively zone out
Okay.
manufactured homes.
Yeah, see,
So I think that's where that came from, just.
And I know that some of our stuff, especially in the UGAs, is based on really what you would consider urban standards, and I think there was an attempt to try to marry those regulations with the city of Pasco in order to avoid creating conflicts. However, I also have a different interpretation of what a conflict is. But that aside, it's just, that's always, but thank you, because that does make sense. It's like, it's that thing. Kind of like the 72 or 32 square foot of glazing on a house.
Mr. Chairman, one
anyway.
more.
Sorry, I'm off a little bit.
One more question. This would go to the planning commission before it comes back to the board.
Oh, yes.
Yes, so
Yes.
just want to make sure that there is additional process.
Yes,
That
yeah.
you may have language in 2 to 3 weeks. It's not coming back to the board
Or,
within 2 to 3
no,
weeks.
it'll be back to the board before the end of the year. Maybe even as early as November, but that's a stretch. Because, it'll go to the planning commission for their recommendation. But then, now we can do that simultaneously. It's just that the board can't take action on the item until a minimum of 60 days is, that the Commerce has had it for at least 60 days. So we'll run that in concurrently, thank you. So that time will be clicking. We'll send it over to Commerce early on, even before the planning commission gets it. And then it moves that process. But at a minimum, we're talking 90 days.
Just as a reference point, really doesn't make never mind, but the north arrow, it took me a while to figure out where it's at. The north arrow on the map is actually pointed west, not north. And so it took me for a while to find
Oh,
it,
you're talking about the actual black and white site plan?
this project. So it took me a while to.
Right. You're
I
talking
knew
about
the location
one.
where it was at, but I couldn't make it right in my mind, and so.
You're right. I didn't notice that. Because the orientation of the property is this way.
Correct.
So that arrow should be pointed
From
not
right,
that direction.
from left to right.
that way. It should be pointed towards that door, not up.
Yes.
We didn't catch that.
All right, any further discussion? Hearing none, at this point, I will close the closed record hearing and entertain a motion.
Mr. Chairman, I move for approval of Resolution 2024-0201 as presented.
Second.
It's been a motion and a second. Any discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Aye. Motion passes.
Thank you all.
Thank you. Commissioner Administrator updates. Start with Eric Johnson.
Well, thank you. You heard part of my update earlier when we had folks still here around the betterments, and so hopefully we'll have that back in front of you after we have some additional review from attorneys once we kind of get the parameters of the elements in place. Attended the entrance conference with the state auditor, so the state auditor will be in the process of working through our financials and audits. I've been spending a lot of time meeting with elected offices, meeting with departments, meeting a lot of folks, touring facilities. I was out at the juvenile justice facility earlier today with Tim. Been to the RV park, been to HAPO, just getting out in seeing elements of the county. Spending a lot of time thinking about the budget process for 2025. We've got a very intense October week set for you, but really thinking about what does part of late September and October look like for sitting with the board and talking about budget principles, things that you want, things that you need to hear, things that you need to see, so that as you go through that intense week of budget workshop time and budget meetings, that we're maximizing what you can get out of that. And then following that, how do we use November for a deliberative process, and what qualitative analysis do you need to make decisions, and so the 2025 budget gets adopted in a timely manner. So spending time thinking about and working with folks associated with that. Appreciate all the work with the auditor's office and others who are very engaged with this process. So I'll stop there. I'm, again, still thrilled to be here.
All right, I'm glad you're here. I appreciate all your hard work and knowledge. Commissioner Bauman.
Thank you, Mr. Chair. It's been a really, really full week, and but a lot of fun. It was the best week of summer, the Benton Franklin Fair and Rodeo, and so enjoyed that. I talked with the director over there today, and so there was over a 6,000 person increase over last year, so there was more than 118,000 people visited the fair despite the day of bad weather. And if for those that went to the auction or the livestock sale, that sale did spectacular. As of this afternoon, the numbers were still coming in, but they have far exceeded last year. So as of this afternoon, it was over $1.4 million in that livestock sale, and that is spectacular. So congratulations to all them hardworking kids that have spent all that time and learned so much, and were able to sell. There were several records broken, is my understanding, for the sale of a number of different animals. It far exceeded my budget. I do know that, and so I'm looking forward to Connell and maybe to have a shot. At the Benton Franklin Fair and Rodeo, there was, as Commissioner Mullen, you shared last week, there was some concern about some vendors and some challenges they were having with some government agencies, and so went and asked them some questions. Was able to get a hold of some of our legislators. Had a meeting with some of the concessionaires there, and a couple of things about that. Just want to say thank you to our legislators. We have some spectacular legislators locally, and just a thank you to those that worked very diligently. I can tell you there's some that worked into the night and early in the morning and was able to meet, and then some of the concessionaires have moved from our fair on to other fairs, and have had a lot of success from all the different people that got involved in that. So just thank you to them. Had a BCES board meeting last week. Had a couple of items before the board. One of them was a proposed budget for 2025, and I've talked with our IS department. We need to look at those budget numbers and have an understanding what they mean for Franklin County, and so ask them for a little bit more of a breakdown. And the other thing was there was a vote by the BCES executive board there, and it was a unanimous vote to start the process to move towards independence for that agency. And I really believe that that's going to be very, very helpful, because sometimes it's very confusing because of the different components of that agency. Sometimes Franklin County has 2 votes, sometimes they have 1 vote, and sometimes there is no vote with different components of that agency, and just the way that's put together. And I really believe that making that a standalone agency will be very helpful in that process. So with that, would love to have somewhat of a consensus, or we can talk about it later, but there's a task force or a subcommittee that is being created to work through what independence looks like and address some of the challenges. And so my proposal would be that I would be the representative for Franklin County, and then if for some reason I needed to be absent, that Eric could fill in for me in that. And so I would like to propose that.
Yes, you have my consensus on that, so.
Same here.
Okay, thank you. Also had a tour of the fairgrounds with some of the board of directors there that run the fair. They had some concerns, and there was also some different legislators and different people that were there and shared some of their concerns. Thank you, Tim. Had the opportunity to come to another juvenile court treatment graduation. Congratulations to that young man and his graduating from that. And it's just neat to see success. It's neat to see efforts and all the time that goes into that, and his willingness to participate in that program and to graduate, and hopefully move forward to a lot of success. Visited the Columbia Valley Center for Recovery today. Been driving by it very regularly, trying to learn, understand, and did not see any construction activity there today. Also, as some might be aware, there's a concern in Fire District Number 5 with some issues out there. So I met with one of the fire commissioners from Fire District 5 along with our emergency management director, and talked through that a little bit. There's some more effort that needs to be going through there. I'm supposed to be talking with the other 2 fire commissioners out there and visiting with them about some of those challenges, and had some extended meetings with staff. Met with Mr. Johnson, and really appreciate some of the experience that you bring to the table. So excited to have you here, and Mr. Chair, that is my report.
Thank you. Commissioner Didier.
Last week consisted of the hazard mitigation plan. Sat through that meeting, and a lot of the department heads and electeds were in that meeting. Went through that. Ben Franklin Workforce Development, and they have a call out for people to donate to this cause for the kitchen. I can't remember the first name of that. It's a fundraising for women to learn how to.
Grace Kitchen.
Grace Kitchen, that's it. And so people may want to donate to that. Celebrated my mom's 93rd birthday on Sunday with my family, and a lot of them were at the fair. One brother drove, the other one used the bus, and the one brother that used the bus, the Ben Franklin Transit bus, got home before my brother that drove got out of the parking lot. So
I can believe that.
This is why the Ben Franklin Transit buses are needed, is for these big events. But again, we're looking at them, and I constantly visualizing or seeing them around town, and the most I've seen is 3 people on one of those big buses. And I think we could far service the people of this community with private sector movement of people through some of these smaller operations. Then I just met with a man today that has a problem up in Colotis, and our administrator met with me on it, and we're trying to help him out on a railroad right-of-way, and we might have to go through the House representative to get that resolved, but I'm going to try to hook him up with that so that he can figure out a way to maybe get possession of this property that's a right-of-way, that there's no railroad there anymore, and he mows the weeds. He's been mowing them for 18 years, and he just wants to own the property, and he should. And then I want to report this out of the Business Insider. Elon Musk says Starlink will let people stranded in the wilderness access emergency services on their phones for free. This is so close, and that's why I think that we maybe just slow down on this tax a little bit. This might be available, and this is Starlink. This is phones going up instead of laterally onto the high antennas. This goes up to satellites, and this is Business Insider, and it's right around the corner, and we can solve our problems, and it's free. So phones, no matter where you're at.
Nothing in life is free.
Well, it says it's going to be free. So I'm going off of what he says. Emergency services only is free. The rest of it will cost money. But this is big.
Yeah.
This is right where we're at. We're on this new technology, and we're still looking at these handheld radios. It's going to cost us 30, 40, who knows how many million.
Well, I will say that Starlink works exceptionally well because we have no cell service like on our cattle ranch for at least 20 miles. And unfortunately, it works like a charm. I get phone calls constantly when I'm in the house.
When you want to get away from it.
Right. All right. Well, thank you.
That's the end of my report.
All right. So last week had the Board of Health meeting. We had a executive session to deal with some issues that we are experiencing with LNI. And again, with the LNI activity out at the fairgrounds, basically using the health department as an enforcement agency. And kudos to Commissioner Bauman for stepping up and getting the legislators involved and solve some very concerning issues that some of the vendors out there had. And it's great to see that the legislators stepped up and got the situations resolved. And some of the vendors out there at the fair contribute quite a bit to the well-being of the Benton Franklin Fair. I don't know if a lot of people are familiar, but some of those vendors pay, $30,000 for 5 days of rent space. So it's can either make or break, and these particular vendors that I know have spent an exorbitant amount of money to try to conform to the LNI requirements, and due to the lack of cooperation and follow-up with the inspections. When you build a trailer to their specs and you pass the planning, pass the virtual, and then are waiting for a sign-off for weeks at a time. Months. It takes about a year. I've known no one that has passed that in under a year. And to spend that amount of money and then be told that you can't operate, it's pretty disheartening and financially a burden. I mean, it could bankrupt some people. Those concession trailers are $350,000, and it'd be like missing a house payment because you can't work, or being asked to operate outside of your booth. And I'm just glad that it got resolved as cooperation with the health department. They're only doing what they were asked to do by LNI. And so it's nothing against the health department. They were very cooperative in working with us. And so I was just glad to see that it got passed. That was pretty much the main topic last week for me, was the health department meeting and the meetings out there at the fairgrounds with the health department on the LNI issues. So
Especially appreciate the Benton Franklin Health District staff and the difficult place that they are put in with LNI not being responsive. Them trying with everything that they have to help these vendors, but when LNI is unresponsive, that is very difficult to very thankful for our legislators and their rapid response.
yes. So that concludes my report, and moving on to administrative office business. All right. Public comment. Is there anyone in the room for public comment? If so, please come forward, state your name, and you have 3 minutes. Good evening.
Al Andrews, frequent flyer. Thank you for all your hard work. I really enjoyed the fair myself. We watched that young man, the Smiley kid, get $39,000 for one lamb. It was $100 a pound, or was $2,900? Yeah, $29,000. So it was great. I think it was dueling grandparents, and I can appreciate that. I just applied for Social Security this week. So, I'm officially a grandparent over and over. But my comment earlier is to make you aware of what's going on in the state. As you work with the legislators on the state level and on the federal level, please let them know that you object to overreach from the federal level. It will come here. And I'm very aware of a lot of tribal policies that oppress them, their own people. It has concerned me for a long time. And I would invite you to look at some resources that help us work better as Americans, because we're all Americans. We're Native Americans. We're all Americans. We share everything. And there's just some that don't feel that way in the governmental level. And they suffer the most. And that's why, you know, I adamantly say that we truly, if we want voting integrity this year, we must call for canvassing on the tribal reservations, because we have 24,000 aliens that have come over the north border. That's in the newspaper. And they don't even have to have a tribal ID to vote. They can be called homeless, and there's a big 1-800 number and a complete apparatus. I've never heard anybody challenge a tribal vote, but they have this massive apparatus just in case. It is a setup. Our country welcomes people. Look at this gentleman that put this beef packing. You know, he still has that lovely, you know, Hispanic accent. He's worked hard. And he's made his way, and he's productive. We need to protect our election integrity. I've been on the phone calling the majority leader of the House, and I do this because I'm an activist. And then I called the whip, and then I started calling everybody on the elections committee, and I relayed to them our situation here. And I reminded them that Kristi Noem just merely mentioned that she was concerned about crime going up on her tribal reservations. They should have said, thank you, please help us get the feds in here. Instead, they banished her because they don't want her to see what's going on there. So, I mean, it's broader than, I know how complicated Franklin County is and working with interlocal agreements, but this is a serious issue. And I'm just going to keep reminding you and keep you on your toes on that. Okay, thank you.
Thank you. Anyone else for public comment, or is there any callers on the phone? All right, thank you. Any need for executive session? All right, no more business for the good of the, with no more business for the good of the county, this meeting is adjourned. Thank you.
We got through it.